some of these quite consequential.
Yeah, we'll get a couple more today on the last day of the court. But yesterday, as you say, was a big day. The Supreme Court yesterday upheld that Mississippi law that allows mail-in ballots to be received up to 5 days after Election Day. That's a loss for President Trump, who repeatedly has pushed unfounded claims of voter fraud when it comes to mail-in voting, despite the fact that he uses it himself. The Supreme Court's decision emphasized the Constitution gives election authority to state legislatures and to Congress, not to the president. It was a 5-4 opinion, with Chief Justice John Roberts and Justice Amy Coney Barrett joining the court's 3 liberal justices in the majority. So let's take a pause here quickly. The significance of this, first, Lisa, is that the president has been pushing and continues to push this idea that we got to get rid of mail-in voting. He just said there no other country uses it. That's not true. Many other countries, of course, use mail-in voting. And we should point out again, as we do every time he brings up this point, there is very little fraud that is found in mail-in voting. A couple examples here and there that he uses as a larger example. But what is the significance to you legally here?
I mean, the significance is that the integrity of the election has been shored up by the Supreme Court yesterday in what was a surprise decision. Many people who listened to the oral argument, me included, believe that the Supreme Court was poised to make the other decision and decide that under federal law, the term Election Day means that all votes not only must be cast by then, but they must be counted by then as well. And the court's decision to go in the opposite direction, honoring the laws of 18 states and territories, means that mail-in balloting will remain secure for November, unless or until the president is able to legislate otherwise. And Willie, I think that's the big open question, because you and I both know the president has had a series of executive orders that are aimed at elections, which right now have been stopped by courts. Some of those executive orders also aimed at mail-in balloting. For example, one of them said that the attorney general should prosecute state and local officials that will allow these grace periods for counting ballots. Now the president, as he continues to push the Save America Act, will he try to insert provisions in that make it harder for these states to allow these grace periods? That's one possibility. But you can count on him to sort of double down on the risks of fraud associated with mail-in balloting, helped along, by the way, by some of the dissenting justices, Justice Alito and his dissent in that decision, basically saying that the fact that these states allow this lends itself to the narrative of mail-in ballots leading to fraud. That's not a helpful comment from a justice of the Supreme Court, particularly given what you said. There is little to no proof that mail-in ballots lead to any substantial fraud, let alone outcome determinative fraud in the 2020 election, despite the fact that the president continues to advance that narrative.
And we should point out this was not a slam dunk. It was a 5-4 decision. Chief Justice Roberts writing the deciding opinion here. But when you say, Donald Trump is holding up legislation, which he is. He's holding up this a bipartisan housing bill to get the SAVE Act through, which, again, would do great damage to mail-in voting. What are your concerns legally about kind of end-around runs that the president and his aides can make around even this Supreme Court decision?
Well, I think there are sort of 2 of them. One of them is just about certainty, right? Administering elections is difficult enough for people in states without last-minute changes. And you can rest assured that the White House, in advancing the Save America Act, they don't care about the havoc that it wreaks for local and state election administrators. They want to get their way. And so that will introduce a whole bunch of uncertainty if they, in fact, pass this law. And it has impact not only on proof of citizenship, but how the voter rolls are certified, who gets to vote and when. That raises just huge question marks over the heads of voters all throughout the country. But the other problem is that constitutionally, the time, place, and manner of how elections are administered in this country belong to the states and not to the federal government. So while there is some language in the majority decision here saying, hey, we're not foreclosing the right of Congress to legislate otherwise, there is a big open question about whether Congress can make a different decision about these grace periods.
There's going to be an extended issue on this, and you just referred to it as poll workers themselves. Who wants to do that job, given the iffy nature of what's going on? But right now, as it stands, off the ruling, if you cast a mail-in ballot the day before election, so long as it's counted within 5 days after the election, that ballot is legitimate? Is that the way it's going to work?
Well, look, you have to live in a state that has a law that provides for this already. And there are only 18 states and territories, 14 states, the District of Columbia, 3 territories that allow for this. But yesterday's ruling, in fact, Mike, means exactly what you just said. If you live in one of those states with a grace period that allows for the counting after Election Day, your vote should be secured under this ruling.
Yeah. Some questions, though, about that 5-day period, given in some states the mail has been slowed down for a number of reasons. Let's bring in MS Now National Affairs analyst John Heilemann. He is a partner and chief political columnist at Puck. Let's stick with mail-in balloting. Heilemann, your thoughts and anything to my concerns about the slowness of the mail if it is a 5-day period. I mean, if it's postmarked, but it can arrive within a good amount of time after Election Day, maybe that works. Is 5 days enough?
Well, I think, Mika, obviously we've seen in the past we've seen much longer stretches than that. I think that there's that it would be good, in fact, to have some pressure on some states to be able to get their acts together to be able to process these ballots more quickly. I think it's obviously from this point of view of the law and the Supreme Court ruling, it's a blow to Donald Trump. It's also a blow to it shores up what I think most of us agree, given the vast record that we now have before us, which suggests that there is no problem with fraud and mail-in ballots that's ever been proven or demonstrated. That's a good thing. The main consequence, I think, on this politically is that as determined as Donald Trump has been to try to get the SAVE Act through, this is just going to increase his degree of intensity and focus on that, which has gummed up the works on Capitol Hill, holding up the housing bill, has held up a lot of things. But I think we're going to see a very...
All right, we lost Heilemann there. We'll get him back in just a second. But just to put a fine point on this, Justice Amy Coney Barrett, who wrote the majority opinion, said of this potential end around, if varied deadlines for ballot receipts similarly call for a national solution, the American people must choose it through their elected representatives. In other words, go through Congress if you want to change these laws, not through us. Meanwhile, the Supreme Court also cleared the way for President Trump to fire the heads of most independent federal agencies at will. It was a 6-3 decision this time. The justices ruling Trump can fire Rebecca Slaughter from the Federal Trade Commission, overturning a unanimous decision from the court in 1935 that protected the independence of government agencies. The ruling effectively makes FTC commissioners and those who staff independent federal agencies serve at the president's discretion and eliminates Congress's bipartisan requirement for the agency. In a concurring opinion, Justice Neil Gorsuch wrote, quote, independent agencies are not so independent after all. Justice Sonia Sotomayor, who read her dissent from the bench, firing back, writing, this court undoes centuries of political practice and concludes that all 3 branches of government have been acting in open defiance of the Constitution all this time. But the court is making an exception for the independence at the Federal Reserve, at least for now. In a separate 5-4 decision, the court ruled Federal Reserve Governor Lisa Cook can keep her job as she fights dubious mortgage fraud claims from President Trump and his allies. Chief Justice John Roberts and Justice Brett Kavanaugh joined the 3 liberal justices in the majority ruling there. So, Lisa, this basically sets the precedent now that you can fire an independent regulator at will. If they're not doing your bidding effectively as President of the United States, you can just get rid of them. That overturns 90 years or so of precedent there. But they do make this carve out for now for the Federal Reserve. What's the distinction between the two?
Well, I can tell you what the justices say the distinction is, and then we can talk about what the real distinction is, if any. You know, one of the things that happened here is that Donald Trump did not contest the constitutionality of the statute that binds him to only fire members of the Federal Reserve for cause. He seemed to accept that that was a given, and then the only question for the court was, what does it mean to fire a member of the Federal Reserve for cause, and had he done it here? But really, there is no distinction, Willie, and Justice Barrett points that out in a dissent in the Cook case. She says, like, how can the court on one hand announce a new categorical rule and on the other breath say, here's the exception to that rule. And if you look at the various opinions here, one thing that I think is striking is there are only 2 justices who are in the majority in both cases. Chief Justice Roberts, who is fighting for the court's institutional life, basically, in every decision, and Justice Kavanaugh, who has gone out of his way time and again to say, in so many words, the Fed is different. That's not an explanation that carried weight with 7 of the justices who in a variety of ways have said, I don't know how to square this circle. This doesn't make a whole lot of sense to me. And the other thing that I want to point out about the Slaughter opinion, that's the opinion through which they have said the president now has the power to fire members of independent agencies or these multi-member commissions. If you read Chief Justice Roberts' opinion in that case, one of the things that is really scary about it is it's not just about independent agencies. It suggests that the president has the constitutional authority to fire any subordinate, meaning he doesn't just have the power to fire Rebecca Slaughter. He might have the power to fire somebody like Maureen Comey, a career prosecutor here in the Southern District of New York, who was fired basically by a letter that says, pursuant to Article 2, you're fired, right? And if that is what the court is saying here or setting the ground for, that means we're not just talking about the evisceration of independent agencies. We're talking about the eradication of the civil service writ large. That is an enormously terrifying proposition at a time where this administration has really hollowed out lots of executive agencies, not only with respect to those people who are appointed, but also with respect to scores and hundreds of lawyers, as our colleagues Carol Leonnig and Ken Delanian have reported with respect to, for example, the FBI or the DOJ.